Bill did ask me to come talk to you a little bit about along the lines of taxes and property taxes. Talk to you about a lawsuit that has been filed. Matter of fact, right now it's kind of an old lawsuit filed back in 2008, and tell you about the potential impact that would have on property taxes. As a just to start it off, how many of you have heard about the Lynch lawsuit? Okay. Well, then let me, since most of you have not, let me kind of go back and give you a quick history of it. I'm going to hit the highlights, but at the Forestry Association, we are particularly, and I'll tell you what stage we're in now, but we're trying to communicate to everybody to let them know that this is out there and let them know what kind of impact it has. Back in 2008, a lawsuit was filed in the Northern District Federal Court. It was filed on behalf of school students, elementary school students, K-12 students in Lawrence and Sumter County. It was filed and received class action status under one of the federal statutes that it was filed under was the Civil Rights Statute. Now, if you want to know detail about this, you can go to our website. And I'll be happy to provide you anything that you want to know, any of the detail. We've got all the filings on that. But basically, this lawsuit was filed. This is a sister suit to the long-running Knight case. How many of you are familiar with the Knight case that ran for about 10 years? It was filed, again, in federal court, alleging discriminatory funding in our four-year college system. In other words, the historically black colleges filed suit saying that they had not received that adequate funding relative to other public institutions. That suit drug out for about 10 years. During that lawsuit, the plaintiff's attorneys attempted to introduce K-12 funding into it. Okay, they attempted to say you have this same racially based discriminatory funding going at work in the K-12 system. The judge at that time said that is not germane to this lawsuit because we're talking about state funding that goes to colleges. Versus in the K-12, it was an issue of property tax funding to K-12, to the K-12 system. So the judge basically set that aside. Now, when that Knight case was finally settled, those same attorneys picked up that K-12 module and filed that suit. It's the same attorneys. They filed it on behalf of, as I said, of students in Sumter and Lawrence County, filed in 2008. When I first heard about this suit, alarm bells started going off, so I went and visited with the governor, and then the governor after visiting with the governor, he pointed me to the Attorney General, so I went and visited with the Attorney General. Come to find out, as I was going through this process, my counterpart at Alpha, Mike Kilgore, was going through the same process. So when we got to the Attorney General, we both converged, and we sat down and had a lengthy discussion with Attorney General King. What we were wanting to hear was that the state was going to vigorously defend the suit, the current property tax system. We heard that, and so we have, ever since then, we have been working, both us and Alpha, Alabama Forestry Association and Alpha, have been working with the Attorney General and with the state's defense team to provide information and to be whatever assistance that we can. Now let me tell you what the suit would do. What the plaintiffs are alleging is that there is the funding that goes to K-12 systems has been restricted, and inadequate funding as a result goes to K-12 system as a result of the 1901 Constitution and subsequent laws that were passed that placed caps on the amount of property tax that could be collected. Now, the 1901 Constitution set in place the property tax system, but back in the mid to late 70s, there were a set of bills that were passed that in essence established our current property tax system. What the plaintiffs are arguing is that the 1978 lid bill and other bills that were passed at that time were grounded in the 1901 Constitution, and that the purpose of the 1901 Constitution was to disenfranchise racial minorities. Okay? And as a result of that, inadequate funding goes to these K-12 schools. Now, that's why that racially discriminatory funding is why it's filed under the Civil Rights Statute. I'll tell you about why that's important in a minute. What the plaintiffs are asking for as relief is that the judge throw out our current property tax system and take us back to where we were prior to 1978. Now, what would that look like? Okay, right now, Kenneth, correct me if I get any of this wrong, but right now, where we are, we have current use, as you heard Kenneth explain. So as your property is taxed, as the tax is figured on your property, you start with current use value if you've applied for current use. That current use is multiplied by an assessment ratio. And I ask, thanks to Kenneth for allowing me to use this slide. But you take the value per acre, which on the right-hand side, current use value, multiply it by the assessment ratio. There's three classes of property. Timberland and farmland is class 3 property, and it's assessed at a 10% ratio. So you take the current use value, multiply it by the assessment ratio to get the assessed value. And then the millage rate is applied to the assessed value. Okay? This is exactly what Kent was applying. If you lose current use, what he showed you on the left, you would go straight, you would use the value, the actual market value per acre, and then multiply that by the assessment ratio. So the plaintiffs are asking to throw out our current property tax law. Okay? That would eliminate current use. So we would go, in this particular example, from $506 to $2,000. You would also eliminate the assessment ratio. So you go from 10% to 100%. Now, I did go to Auburn, but I think that I can figure out that if you go from 10 to 100, that's a tenfold increase. So you lose current use, you lose the assessment, and the millage rate is applied to the whole thing. So you wouldn't go to $770, you would go to $77. $70 an acre. Now, excuse me, you're right, $77. See, I told you I went to Auburn. Okay. Yeah, got Bam on his socks here. Okay. $77. Okay, now, needless to say, that's a big deal. That's a huge deal. Now, we talked, Kenneth put up a slide about Georgia. Let me give you a little personal experience from Georgia. My wife has a 3.5% interest as a result of some family property in Chatham County, which is outside Savannah. This is development property. It's right on the edge of development. We were about to sell that several years ago, and right before the property, the real estate market took a dive, and so we let they call it CUVA, the Conservation Use Value Agreement. We let that expire. So we lost, in essence, the current use. But we thought we were going to sell it. Unfortunately, the deal fell through. So here we are, still with the property, and now it's being assessed and taxed at the market value rate. We finally got the CUBA back on the property, but our tax bill, and this is for about a 120-acre tract, our tax bill without current use is $24,000 a year. Our property tax this year went to, this year will go to $700 an acre. Okay? That's huge. And I believe me, as we've got, as a family, there's about 8 people in the family, we've been scrambling around every 6 months, because we pay them every 6 months. We've been scrambling around trying to come up with enough money just to pay the tax bill. But that's the potential for this particular lawsuit. That's why we dove in feet first. That's why Alpha dove in feet first. And we are working with the state. Now, let me tell you the current status. Oh, excuse me, let me back up. If the plaintiffs receive a favorable ruling, here's what would happen. If the judge rules in their favor, then that doesn't automatically mean that the taxes go up. What happens, obviously at that point, the state, and at that point we will have officially intervened. So we would appeal that, if we lost on appeal, then what would happen is the legislature would have 1 year to come up with a new tax system. Okay, ad valorem taxes. If at the end of that 1 year, okay, they would not only to do that, they would have to pass legislation, and it would also have to go to the voters for as in the form of a constitutional amendment. So our assessment is that would be highly unlikely that the legislature could get something like that done within a year period. At that point, if they didn't, then the court, the federal court, could try to impose their own system. And I can assure you that that would not be favorable to property owners in Alabama. So this is something that we are following very closely. As I said, we're working with and trying to be. We're being a resource to the Attorney General and the state's team, providing information, anything that we can do to make sure that they have what they need to vigorously defend the state. Unfortunately, if they do get a favorable ruling under the civil rights statute, then the state, you and I, the taxpayers, are then obligated to begin paying the plaintiff's legal bill. So you can imagine what the plaintiff's attorneys might do to stretch out that process. The Knight case was a 10-year, it took 10 years, over 10 years to settle. So that, we hope we can get a quick ruling on that. We expect that an appeal was filed by the state with the 11th Circuit, asking that the 11th Circuit step in and dismiss the case. The 11th Circuit summarily dismissed or rejected that appeal, so we expect it to go to trial within a couple of weeks. Not a couple of weeks, within a couple of months, 2 or 3 months. That's where we are on that. You need to know about that. We will be doing our best to provide you information to keep you abreast of that.